Hey everyone, welcome back to the Above Board podcast. Today I am grateful to be joined by a friend and work colleague of mine, Jennifer Bondy. Jennifer is an Orlando-based estate planning and probate attorney. She is the founder of Bondy Law, which is a boutique law firm focused on helping families protect their assets, navigate life transitions, and avoid the pitfalls with their planning. She is known for simplifying complicated legal issues and designs practical, high-touch plans that reduce stress for families during life's most difficult moments. And I'm especially excited to have Jennifer on with us to help us unpack some of the legal jargon that we all hear, and maybe even debunk some myths that we've learned over the years regarding estate planning. Jennifer, welcome.
Yes, thanks, John. I appreciate you having me today. I'm really excited to talk and hopefully educate the audience.
Yeah, I'm happy that you're here, and thank you for saying yes and joining us on the show. If you don't mind, maybe let's start with I'd like to just give our audience like a brief background or understanding as to what led you to this type of career and work that you do.
Oh, that's a great question. I started my career in banking. So I think I kind of always had a little bit of a inkling towards finances and numbers, and then people's money starts to make you think about planning and whatnot. After I was in banking for about a decade, I wanted to go and further my education. And thanks to my mom kind of pushing me in this direction, I decided to go to law school. And so I always kind of wanted to focus my career not on litigation or family law, those type of things, but more on, real estate transactions is kind of what I wanted to focus on. And then that led me to people who own real estate want to protect their assets. People who own property then have to pass it to their families. So the natural progression was kind of initiated by the real estate, but then the people involved with the real estate and how they want to protect it during their lifetime and make sure it passes to their family whenever they pass away. So I've really focused on those practice areas my whole career, which is about 13 years now.
That's cool. I don't think I didn't realize that that's what led you into this profession. And you have an additional firm called the Closing Lab, right? Can we talk about
Yeah,
that
we
for a moment?
Yeah, we have a title company. So we do residential and commercial transactions through our title company. And that's kind of separate from the law firm because it's specialized just on the transactional piece. I didn't want people to kind of integrate that I would be their lawyer in the transaction. It's really to facilitate the transactions. And then the law firm allows me to have the direct representation and again, focus more on the asset protection strategies.
Yeah, I like how you said that though. Like I don't think my brain would have thought because I look at those, let's say estate planning and, real estate transactions as two very different things. But
Yeah.
at the same time, how that story kind of led from one turning into the next, it is sort of a natural progression. And I always feel like your line of work, same as my industry, but the goal is to help people do the planning before
Yeah.
the problems and pitfalls occur, which is interesting because I think people are, they're mindful of what they're spending for services and as they should be. But then maybe because there's not like a deadline or something urgent driving that, it's like it's a future problem. And then it
Yeah.
maybe leads to procrastination. And so maybe with that in mind, kind of going into some of the estate planning stuff, could you talk to us a little bit about the consequences of not, I mean, I guess let's go like to the one extreme. Like we don't have a estate plan in place at all. Like
Yeah.
what happens if we have nothing set up?
I hate to give the standard lawyer answer and it depends, right? But really it's fact specific depending on what your family makeup is. So
Okay.
the answer is if you don't have any planning in place, the state statutes tell us what should happen to your assets, who they should pass to based on your family status. So whether you're married, whether it's a first marriage or second marriage, meaning if your kids are in common with your current spouse or you have children from another relationship, or if you don't have children and then it goes to like your parents, your siblings, etc. So there's a common misconception that people think if they don't have any planning, all of their assets are going to go to the state. That's
Mhm.
not true. The only time your assets go to the state is when it's unclaimed property. And after a certain period of time, those institutions have to turn your assets over to the state. But as far
Mhm.
as the recipient of the assets, the state statutes tell us who those people are depending on your family status. And so that kind of leads us to, well, does the state statute and the direction that would automatically flow, you know, conflict with what you would want to happen to your assets? Because that's what
Well,
happens
I
a
was
lot
gonna
of
say,
times.
yeah, I feel like that's very vague. Like, so
Yeah,
there's a way that will go, but that's
yeah,
still somebody else or maybe a court system determining
yeah.
to the best that they can how that should go, and you don't necessarily want that, right?
Yes, and it's not always what people think is going to happen. Most married couples think that all of their assets are going to go to their spouse, but as we kind of touched on,
Oh,
if it's a second marriage and you have children with a prior spouse, your assets aren't automatically going to go to your spouse. They are going to be split between your spouse and your children of a different marriage. And so that sometimes can be a very tough conversation to navigate and a very tough place for a surviving spouse to be in, who maybe thought they were going to receive the home or receive these other assets, and then come to find out, well, you'll get 50% of those assets, not 100%. And so I always tell people that planning really is to benefit your family, just to make things easier and smoother for your family members when you pass on, so that they don't have a huge burden on their plate.
right. And when can we back up to when we say estate plan? I have an idea in my head of what I mean when I ask someone if they have an estate plan set up. But because a lot of times people will say, like, oh, I have a will.
Hmm.
And like that's what they're thinking. But there's obviously a lot of other documents, and you don't have to get in the weeds of every single one of them, but like maybe just highlights what would someone that's listening to this that doesn't have an estate plan in place, or they're thinking about like, I did one, but it was 15 years ago. What are the pieces that would make up an estate plan for somebody?
Yeah, that's a wonderful question. I'm glad you asked it, because I think, me as someone in the industry, right, I automatically know what I think these things mean, and that could be different from what someone else thinks. So when we talk about an estate plan, we look at it as a holistic approach. So absolutely, a will is a piece in that plan, right? The will is the document that gives us direction and says what you would like to happen when you pass away. But I also like to talk about kind of what are those lifetime circumstances. So we'll include a power of attorney, where you designate someone to make financial decisions for you during your lifetime. Because there's certainly occasions when something could happen to us and we're not able to make those decisions for ourselves. And, it's not just at the time of death, but during your life. We also do the healthcare surrogate designation and living will. So you designate someone to make medical decisions for you. And then the living will, sometimes people have called it like advanced directives or DNR, where you designate in advance if you want life support in certain scenarios. So those are all the pieces that we would look at as a basic estate plan. Then obviously there's a trust-based plan, where depending on the makeup of your assets, the size of your estate, you may want to look at some more complex planning for, again, during your lifetime, and then maybe look at making some more strategic decisions for how that plan would pass upon your death.
So, okay, so if I hear that right, it sounds like an estate plan is, you have the last will and testament, but then you have the living will, which you called like an advanced directive,
Mhm.
power of attorney, and healthcare surrogate, right?
Mhm.
Those are kind of the main. And I think that's important to know, because the power of attorney, for example, I mean, there's circumstances where, I mean, I don't know probability of how often and frequency of when things are used, but I'd imagine there's a lot of situations that come up in life where you need someone to be able to exercise that power of attorney for you,
Yeah,
and
absolutely.
it's equally as important potentially than the rest of the estate plan.
Absolutely. And I always try and tell people, like when I mentioned that, I tell people estate planning helps your family. Well, these other documents are the things that help you during your lifetime. And I find those to be as important, if not more important, than what happens when you pass away, right? And there's a variety of scenarios when those documents come into play. One thing common I think of, because I do real estate transactions, is selling a home, right? If one of your parents gets into a state where they need to maybe move in with one of their adult children and they're starting to lack capacity, a power of attorney is a great document where we could utilize so that that property could be sold.
Mm,
Part of the issue is that if you don't have the documents in advance, you can't get them after the fact. We have people call all the time and say, oh, I need a power of attorney for my mom. She has dementia. Well, it's too late. The person giving the power away has to have their mental capacity and the ability to sign and make those directions. You can't get power over someone unless you do that through a court. So someone has to voluntarily give it away and have the capacity to do so.
again, the importance of doing the planning
Mhm.
ahead of time so that you're not dealing with all of the ripple effect and just the legal challenges of trying to do something in real time or after the fact.
Right. So much more
Um,
stressful that way too, right?
yeah, yeah. And
Mhm.
and again, I think it's easy. Like I have a lot of instances where obviously we don't do the estate planning, but it's a conversation that comes up a lot, and
Yeah.
people bring it up, and then from one meeting to the next, I go, hey, where are we at with that? And like, oh, still thinking through it. And sometimes there's procrastination on who maybe the family members or the players that are going to be a part of it. Who do I want as the trustee, or who would I want to be the
Mhm.
guardian for my kids?
Mhm.
Like, I think that in of itself is a hard conversation. But it's one of those things where it's just such a good point as to why doing this ahead of time matters.
Yeah.
And not only at passing, but if you're just in a situation where you're not available or you're incapacitated and the power of attorney needs to be enacted. What about, you had mentioned a trust, which I presume you're referring to a revocable living trust,
Right.
possibly.
Mostly. Mhm.
Can you give me like a circumstance, a situation that would come up where a family would go, oh, I'd really benefit from having that? You don't have to go through all the reasons why someone should or shouldn't have a trust, but just like a good circumstance, something that you've come up with, you've seen over the last couple of years in your career where like that really helped them out.
Yeah, so I can think of two that come up pretty frequently. The first one is everyone wants to avoid probate. And I will caveat that with probate is not as big and scary as people think it is. What makes
Oh,
probate terrible is the family fighting. It's not the process. But I would say most people say, I want to make it easier for my family and avoid probate. And so by implementing a trust with your plan and working with a financial advisor like yourself, where we can make sure the trust is properly funded, meaning there's assets in the trust to make the plan work, then it's so smooth, so easy. We don't have to go through probate and things pass right along. The second scenario is when people want to have some control of their assets after they pass away. So maybe you have children who are in their young 20s and you say, well, I don't necessarily want them to get $1 million a piece, or, $100,000, whatever that amount is that seems significant to you. Maybe that money wants to be controlled where we have a limitation that a certain amount can be used for their education, or they get payments at certain age milestones so that we have some control. And so that's best done through a trust because we have the control to keep the assets in that one trust, but then allow the payout over a lengthier period of time, where a will it's triggered by the death, the payout happens right then.
oh gosh, I have so many questions about probate now.
Yeah, I'd
So
love to tell you about it.
I don't think I've ever heard it referenced that way, because I always thought of it like, well, we want to avoid probate for the sake of avoiding this like public process where it's going to the courts and there may be so actually, let me back up. If you pass away, you don't have a revocable living trust, but you do have a last will and testament. Is it safe to say that like the probate court is going to look at that? They're going to see, okay, this is kind of how they wanted things to flow, and now we're going to determine, or we're going to pay these things out the way that this document says. But there could be conflict amongst. So the actual bigger thing is potentially the conflict amongst the family, not the probate process itself.
Exactly. And that conflict can happen with a trust as well. And so I think there's a misconception that a trust is better than a will because of the potential for someone to challenge it. But someone could challenge a trust just like they could a will. Um,
Anyone can sue anyone for anything, right? It's
yes,
yeah.
exactly. Not to say that they'll win, they won't be successful. And hopefully we've done all the things correctly so that we could prevent them being successful on those challenges. But absolutely, they have the ability to challenge it. So um, probate, which I also found that some people may not know what probate means. So probate is just the administration process of when you pass away, your assets passing to your intended beneficiaries. Um, and so that is, just like you mentioned, a process where we would submit the will to the court. An attorney would be involved. So we would prepare all the documents. We would have the court confirm that the will has met the execution requirement, so it's valid. And then we would assist the personal representative with ensuring that those wishes are carried out. And so really the court is just kind of minimal oversight. And
Mhm.
even the fear that it's public, Sure, it's a public document in that they know that a court case has been filed, but still the documents themselves are private. It's not like someone can just go online and pull up a copy of your will. They're all protected, and only people who have like attorney access to the court documents are able to request copies from the court. So it's not, you know, just out for all the public to see.
That's actually really helpful for me too. Like, I don't think I realize all those things. And then follow-up question with probate, does it potentially slow down the process of assets going to where they need to go versus a trust might be a little more expedited? It's very clear, here's what we're doing, and money gets paid out.
Yes, so there is certainly the potential that there's a bit of a delay when we go through the probate process. When someone passes away, we do have to pay their creditors. And so part of what we do in probate is we have to file a notice to creditors and give creditors 90 days to submit a claim. So typically, other than some certain allocations, like the homestead property and some family allowances, we would have to wait until the creditor period has passed before we could make the full distributions. So a trust would avoid some of that, although the trustee would have the obligation to pay the debts of the, the settler of the trust. But then also, one thing that people often forget is with a will-based plan, you can still avoid probate. So it could be that we utilize beneficiary designations. As I'm sure you know, when there's beneficiary designations, those don't go through probate either. Those would pass directly to the named beneficiary. So sometimes we can still avoid probate even though someone's elected a will-based plan because of the other strategies that we implement through pay on death beneficiaries, maybe joint ownership with spouses, etc. So there's a lot of options that we can utilize.
And then with a will-based plan, like you said, any account, 401ks, life insurance, bank accounts, you can all list beneficiaries. But let's say you own your home. Is there something you can do with that as well? Or will that always have to go through probate unless you have a trust?
So there is an option where we can essentially name a pay on death beneficiary for a property. So in Florida, we have what's called an enhanced life estate deed. And so what an enhanced life estate deed is the ability for you to say, during my lifetime, I want to retain all the rights in this property. But when I pass away, and only when I pass away, I want my property to go to this person. So if we've got, a husband and wife and maybe, or even an individual person, and maybe they have one or two children, they say, okay, I want the property to go to my two kids. We might be able to utilize the enhanced life estate deed so that property would be able to avoid probate. Again, sometimes there's caveats to that because if they've got more complicated plans in their will where they want certain financial assets to be passed to certain family members or different percentages, like we can't get complicated with what we can put on the deed. So that might intentionally go through the will, go through probate so that it passes through the will as opposed to the direct beneficiaries.
And I like what you said a couple minutes ago about, because I just keep thinking about the trust. So, it sounds like the two main advantages are probate avoidance, if that's something that's of importance, and then control.
Yeah.
And so, control being, how do you want these assets to pay out over time? Maybe like you said, you have adult children, but they're not maybe they're not like financially responsible enough yet. I mean, I think, a 22-year-old is an adult, but might not be ready to receive a sizable inheritance yet. And so you want to be able to kind of stretch that out over time. But what about, because you were talking about if there's family disputes over assets and that could slow things up in the probate process. What about that? Like, what about disinheriting a family member? Because that conversation is coming up more and more in my client meetings where they go, I do not want this person to get out. And how does that go? I mean, that seems like anyone can sue anyone for anything, right? So that seems like it could be a problem.
It could be. I'm glad you asked that because that does seem to be coming up more and more. I think it used to be maybe a little more taboo and people still do feel uncomfortable when they bring it up to me. Hey, I've got this strained relationship with someone in my family. I always try and, give them some comfort. I've seen all kinds of family dynamics. So nothing that you say is going to, usually shock me. I've seen it all. So my goal is to make sure that you give me all the information I need so that we can properly prepare the documents. And so disinheriting a family member is especially important because we have to put express language in the will or even in the trust to indicate that was intentional. If we don't put the express language that you're disinheriting this person, then there is more of a potential that they could challenge it, because they could say, oh, well, they just forgot to include me. Like, oh, I want my assets to go to my 3 children, but when there's 4 children, well, they just made a mistake and forgot to include me. Where if we specifically say, I've disinherited this person, then there's no question that that was intentional.
And obviously, in it sounds like you could go either scenario with that. You could go a will-based plan or a trust,
Mm-hmm.
and have that language in either one. Is it
Yes.
your experience that in a situation like that where you have 4 kids and you do want to disinherit one of your adult children, I know this is kind of like hard to, but like, would it be more advantageous to say, hey, let's have a trust for this specific nature, or does it not necessarily matter and you could go will-based or trust-based?
For exclusively for the disinheritance language, it doesn't matter.
Okay.
So now, again, I only gave 2 scenarios of when a trust is
Yeah.
beneficial,
Well,
because
also I'm
those
asking
are
you like
often, but
legal
there's
advice on the
yeah.
podcast, so I know it's
Yeah.
tough.
Well,
Yeah.
and there's a host of other reasons why we might implement a trust in
Right.
a plan. And as you know, there's also different types of trust. So maybe we do an irrevocable trust for different strategic planning, whether that's tax planning or whether that's Medicaid planning. So there's a variety of reasons, and those would be more of a tailored conversation with the individual. But as far as the disinheritance, we could do that with either plan.
Got it. Can I tell you something that's scaring me that I'm hearing
Yes.
more about? It's not so much coming from clients, because I think the clients that we serve, they value the relationship of working with a financial professional,
Mm-hmm.
and they understand when and where using a service-based professional for things versus like DIYing it is
Mm-hmm.
important.
Yeah.
But I am hearing just more people talk about like, all right, ChatGPT is my lawyer,
Yeah.
and I I think this is coming up more, and I imagine this has got to be like an attorney's dream come true, because I'm sure an attorney is like chomping at the bit for a ChatGPT contract to come their way so that they can most likely tear it apart. I don't know. Like maybe I'm making that up in my head, but it seems dangerous to
Yes.
rely on like a AI thing to draft a document. What say you?
Yeah. So I'll tell you, from this attorney's perspective, it's not a dream, because the documents do come out, unrefined and have improper
I
language.
didn't mean you, Jennifer. I
Yeah,
mean
yeah.
like the
No,
attorney that's
but
like, I'm gonna bill hourly. I'm gonna,
yes.
like now all these problems have come in. I'm coming in after the fact. I'm gonna bill hourly. This is gonna be really expensive. And so an attorney's probably
Right.
like
Well,
ready to,
sometimes
but
that's a
you do the
problem.
planning ahead of time. Yeah.
But that's a problem, because if you've got a client who their opposing party is using ChatGPT and they're paying you hourly to, basically negotiate with ChatGPT, that's horrible for us. So I do see that coming up a lot in the legal community, but specifically for planning, um, I have had people that have mentioned, doing ChatGPT with their will. But ChatGPT just is based on, or any, AI driven, whether you're using Gemini or, any of these other programs, it's all based on what you prompt it. So if you just say draft a will for me, well, it's just going to draft a will. It's not asking you about your specific scenario, where when you're working with a professional, I know why we're putting certain provisions in your will. So I'm asking you intentional questions so that I know, okay, are we putting this provision or that? So
Hmm.
ChatGPT and the way those AI programs are, it's just to complete a task. It's not to do thought provoking questions and say, well, did you think about this? So there are a lot of gaps that are going to happen, because you, as the person prompting it, don't have the legal expertise and the knowledge to know what questions you should be asking of the document. And so you'll read it and it looks good, but you don't know that a huge provision that's really important to your plan is missing.
Yeah, and I should have prefaced that statement by saying I spoke with another attorney that does like contract law, and he was sharing with me, and the conversation came up because I knew someone who used it to basically draft up like their lease agreement.
Yeah.
And my comment was, that seems like a really, really, really bad idea. Like I just think it's gonna miss things. There's gonna be loopholes. And that attorney who
Mhm.
I was speaking with said, yeah, like that's like I would have a field day with that, because if
Absolutely.
I was representing the other party that in a lawsuit and this contract was the thing hinging it all together, I would have a field day with it, and I would really be able to go in and pull it apart. And the comment he made was like, we're starting to see a little bit of that, which
Hmm.
is scary. So, I think I mean, I've heard you say this before too, but like you pay for peace of mind and assurance that a professional who knows like this is what they know, this is what they do versus using something like that, or even some of these like online legal services that probably strip out all of the context and the conversation that goes into informing what the right plan is. I mean, I think about like my industry, ChatGPT could put together a portfolio.
Yeah.
It can, but it probably like, where's it going to help you when the markets drop 30%
Hmm.
and your entire strategy is being tested and your emotional well-being is being tested during a turbulent time? I think that's where, the planning and the humanized element of the customization of putting that plan together really, really shines, in my
Yeah.
opinion.
I 100% agree. I think the personal relationship that you develop with your clients is going to be what kind of sets us apart from utilizing the AI elements, because they're not going to be there to give you that advice and counsel, right? So, and even if I've had someone that, I mean, I haven't seen this yet, but I'm sure there are people who have, Chat GPT draft their trust. Well, if they don't know the mechanisms to even fund their trust, right, it still may just be a stack of papers and it's meaningless. So, um, I can tell you so many times I've had clients that have come into me and they think they want one thing, right? I need a will, or I need a deed, or I need a trust. And then through those exploratory questions, we really come up with a different plan, because we can accomplish the same goal with multiple avenues. And there may be consequences that you're not thinking about when you come in and you think straight through, I want this, where I say, well, if we do it that way, here are some of the consequences. But if we do it this other way, we avoid those consequences and still accomplish the same goal. So sometimes people that come see me for one thing leave with something else while we're still accomplishing their goal. And you're not going to get that through one of those, do it yourself programs or an AI, assisted document.
Yeah, and I think you mentioned something that is worth highlighting, which is you do all the work to create these documents, and then I'll use a football analogy, but it's like you get the ball to like the 1 or 2 yard line, but then you don't punch it in the end zone because you don't actually fund the trust, or you don't
Mm-hmm.
update the beneficiaries to reflect
Mm-hmm.
these documents that you spent a lot of time thinking about and working with an
Mm-hmm.
attorney to craft or create. I've seen a couple of scenarios. Fortunately, one instance, basically resolved it ahead of time and said like, "Hey, you did these documents like 3 years ago. Did you ever actually do anything with it?" And they said no. And then I've seen another one where they they actually used like an online service,
Mm-hmm.
and they did all the documents and they thought they were fine. I said, okay, great. Just send me a copy of those executed documents. So I'll keep them in the file just so I have the POAs and I have everything. And they sent it to me and I said, hey, everything is like, nothing is signed. Nothing
Oh
is
my gosh.
notarized. And they go, oh, well, yeah, we'll do that. And I said, no, time out. Like, I hope this is as if it doesn't exist right
Mm-hmm.
now. Right. I mean, maybe I'm wrong, Jennifer, but like I they didn't sign it. They didn't witness it. Nothing's notarized because they used an online platform and then they just thought it was fine. And so it was a great opportunity to learn ahead of time. Hey, we need to redo this. But I'm sure you have experienced those types of horror stories as well, where you're just like, oh no. You probably even witness it after the fact, potentially, where someone's coming to
Yes.
you, and that's
Mm-hmm.
got to be so just terrible for those families to experience stuff like that.
It is. And that's part of the issue with planning, right? It's great when you do it ahead of time, but when it's done wrong, most of the time we don't find out about the issues until someone's passed away and there's nothing we can do to fix it, right? They come in and they say, oh, my dad had a trust. And I say, oh, great. Well, what's in the trust? And they look at me like a deer in the headlights, because they don't understand that really a trust is a two-step process. And I had a client that gave me this analogy that I love to use. A trust is like a suitcase. You still have to pack it. So
Right.
then most people think, oh, I've got to trust, and it's kind of set it and forget it. And it's really not. You still have to be strategic about putting stuff inside the trust, which is why I love working with clients who have financial advisors and professionals that, are thinking about these things as well. So they get that extra support. Like you mentioned, I mean, I may have a client from 3 years ago that never funded their trust, and they come see you and you help them make sure that that piece gets into the puzzle.
I want to ask a question. I know I'm kind of going all over the place here, but What happens when somebody moves out of the state? Because I think a lot of people think like, oh, okay, I drafted my documents in the state of Florida. I now move to Oregon. I'm fine. But that's not the case, right? Because this is state to state specific.
Somewhat, yes.
Okay.
So obviously, I can really only speak to people moving into Florida since my license is in Florida and I know Florida law, but I guess I'll somewhat assume that most states will have similar language. But in Florida, we do have a statute that says if your will was validly executed in the state it was drafted in, we'll assume that it's valid here. So there is some ability for us to have things probated and considered valid in Florida, even if they were prepared according to another state standards. Now, the caveat to that is like when we talk about those online platforms, right? If you're a Florida resident and you got a document that's executed to New Jersey standards, well, that's not valid because you're a Florida resident when it was drafted, so it should have met Florida standards. That also comes into play a lot with the power of attorney. So in Florida, our statute is very specific that says that your power of attorney document has to reference the powers that are given in the statute. So whenever you move from another state into Florida and then say you take your power of attorney to your bank and say, oh, I've got this Oregon power of attorney, and they're going to say, oh, well, it doesn't have the statutory language that we need. So
Mhm.
it may be that you can still push it through to their legal department, get someone to, confirm that it's valid, but it would be much easier if we just kind of refresh some of those documents just so when the time comes that you do need them, we make it as simple as possible.
Yeah. I mean, it's just all the more reason to work with an attorney for,
Mhm.
I mean, that's not even that complicated of a situation, but it's like I moved from one state to the next, or this happened. And you want to make sure, I mean, the two things I heard of earlier on of maybe it's probate avoidance, maybe it's control and making sure that the assets are disseminated the way you want them to at
Mhm.
passing, or just maybe it's I'm incapacitated. I need someone to exercise a healthcare surrogate or a power of attorney.
Yeah.
These are just really important. I mean, when I meet with folks for the first time, it's like one of the first things I talk about.
Hmm.
And I go, I know this is boring because you're wanting me to talk about like what we're going to invest your portfolio in. But if we do all this really well, but then the assets don't go the way that they need to, or we don't execute this part of the plan, it's a big issue. And I think it just everything we're talking about today, which is kind of fun because it's different than the normal conversations we have on this podcast, but at the same time, like I feel like this is like very specific and like anyone listening to this applies to. You
Yes.
know, I
Hmm.
think everyone needs to have these things, even if, and I hear this a lot too, people will say like, well, I don't have a lot of assets yet, so it doesn't matter. And it's like, well, okay, but it's not even just about the assets. It's the power of attorney, the healthcare
Hmm.
surrogate, things like that. What would you just say to someone that said that to you? Like, oh, I don't have, all I own is my home and I don't have a lot of assets. It doesn't matter.
Yeah, I mean, obviously, I get that just as you do. People say
Yeah.
that all the time. There's obviously the estate plan, as we talked about, is kind of holistic. There's so many scenarios that aren't related to just assets that the estate plan will cover. One thing that comes up more commonly is digital assets, right? You've got your Facebook account, your Google Photos, or your iPhone or Apple Photos. It's not the same as when we used to have picture photo albums. So nowadays, having that language in your will or in your trust so that you designate that someone's got the authority to access those digital assets, that's a huge one that I'll tell people no matter what size your estate is, you want to have someone with access to your digital assets. The other thing is, I think when the estate is smaller, it's even more important that the planning's in place because maybe the family doesn't have the resources necessary to go through the probate process or to challenge a document, right? So we want to put them in the best scenario to make sure that the assets that you have accumulated are going to pass to your family members as you intended. I've certainly done probate for someone who had a $5,000 life insurance policy that they forgot to update the beneficiaries from their spouse to their children because their spouse had predeceased them. And we did probate, right? They spent $3,000 to go through probate to get a $5,000 asset, where had they just had a proactive conversation and updated their beneficiaries, that would have been avoided.
Jennifer, this is awesome. Great job today. I really appreciate you joining us. I think um, I loved this conversation with you because these are the things that like we talk about with
Mhm.
clients all the time. And as you can imagine, as a financial professional, like I can only go so far. And
Yeah.
I think that's where you really come in to the fold as an attorney, but specifically specializing in this area of planning to kind of take it to the next level and be able to customize things. As we're wrapping up today, Jennifer, I have a couple of things. Number one, where can our listeners find you? And second one would be just any parting words of wisdom to leave with our audience today.
Oh, I wish I had thought about my parting wisdom. So they can find me on the World Wide Web. Obviously, if you just Google my name, Jennifer Bondy, you will find my website, our Facebook, our LinkedIn, all of the things. So very easy to get a hold of.
And your website is Bondy. It's
Bondy.law. Yeah, it's
Okay.
super easy. That's Bondy, not I. So with Pam Bondy, the Attorney General, now people will misspell my name more frequently than they used to.
Solid point. We'll put that in the show notes so everyone has the link.
Thanks. And then my parting wisdom would, I guess, just be to be intentional about what you're doing, right? As you mentioned, people want to look at the fun, what is their growth going to look like when you can say, oh, if we do this with your assets, it's going to gain, 10% year over year or whatever. I don't know. That's your wheelhouse. But for me, I see people so many times, they're so focused on what they're accomplishing and they never take a step back to really say, okay, well, what happens if something happens to me? Right. So just sometimes take a step back. If you died tomorrow, does your spouse even know that you have life insurance? Do they know how to access your bank account? Do they know where all the assets are? If the answer to some of those questions is no, then it may be beneficial for you to really start thinking through some planning. And we can do that, through some very baby steps and get you to where you need to be if that feels overwhelming.
Yeah, I love that, be intentional with it, but then also realizing like it doesn't have to be this like big, painful, awful conversation. Even just some small baby steps along the way to kind of help make sure things are positioned correctly. It doesn't need to be overwhelming.
Right.
Which I think that's important. And I hear that a lot from people. It's just like, this is overwhelming. This is a hard conversation to have. And so what do we do when things are hard? We avoid it. And I think that's what, the good work that you do and what I try to help employ people with too is just don't avoid it. Don't avoid it. Let's just be intentional about it. So, Jennifer, thank you for hanging with us today and joining the show. And thank you, the listeners, as always, for listening to the Above Board podcast. We love these conversations. We love our community and our audience. If you prefer to watch these conversations like this instead of just listening to them, head over to our YouTube channel, subscribe to our podcast. You can find us at Candor Path or search the Above Board podcast on YouTube. Thank you all for hanging with us today, and we look forward to seeing you next week.